My name is Ari Wilkenfeld. I'm a civil rights attorney, which means that the majority of my cases are employment discrimination and harassment cases. I've been doing this for about 28 years. Our client was a market director for a major insurance company here in the United States. And she and a bunch of her subordinates were at a convention where another officer of the company told a group of young females that the only way they would ever be able to get ahead of the company was on their knees. When our client complained about this comment and some other sexist and discriminatory events that occurred, she was ultimately terminated. And our case was about righting that wrongful termination. What the case ended up being about was how they got rid of her. And what they did is they eliminated her market and combined it with another market that was next door and told her she could apply for the new job of the market director of the new market, but that she ultimately didn't get that job. We argued, and this is where the graphics come in, that her market should not have been eliminated the way it was. The way they eliminated it was through what they call a consolidation, where everybody has to apply for new jobs, and they had the opportunity to get rid of her. But most of the time, they use a process called realignment, where markets are simply combined and no one has to apply for their jobs. They just continue on in the same jobs. And it was very difficult for us to sort of explain the difference between these two mechanisms because they are so similar and their outcomes are vastly different for the people involved in the market. We found that explaining the difference between a consolidation and a realignment was very complicated. It was hard for us to understand it, and it was hard for our mock jurors to understand it also. And that's when we decided to reach out for some graphic design help. We faced three main challenges. One challenge is something that we always face doing plaintiff side work, which is a disparity in the resources that we have available to us versus what the defendant has available to them. The second complicating factor is that there were some very technical terms in terms of the way these markets were combined that we found ourselves having a lot of difficulty trying to explain to people. The third obstacle that we faced had to do with the fact that while our client's job was eliminated, she technically was allowed to apply for a new job, which she didn't get. The response we had to that was that the interview panel was stacked with a number of people who didn't like her, including the guy who said the only way for women to get ahead was on their knees. So that guy ended up deciding whether or not our client would get the new job. Our goal in this case, as it is in most of our cases, is to prevail, to win big, and make a statement. We're impact litigators, so we have an obligation to our clients to do our best and to try and win the case. But we are always trying to win in such a way that it teaches the employer a lesson and that it changes the way they practice going forward. The most important thing I can say about DK Global and its work in this case is that they really worked with us to equalize the resources that we had available. We didn't have a massive budget for graphics. We had a modest budget for graphics, and they worked with us and gave us a really high quality product that ended up being very persuasive and very usable during the hearing. I found DK Global by just doing a simple Google search, and I filled out the contact form just like our clients do with us, and I got a call back pretty quick, and it seemed like a great fit, and we're very, very happy that we reached out.